Mr. Copeland, last fall, the Supreme Court issued a decision in the case known as West Virginia versus the EPA. The case is significant for a number of reasons, but particular to the matters of the day, would you explain the Supreme Court's position regarding a federal agency's regulatory authority over significant policy matters? Then I'd like to see how it applies to the matter at hand.
Yes, thank you, Mr. Chairman. The West Virginia v. EPA decision last year formalized at the Supreme Court what we've seen in a number of other cases, as well as in the appellate courts, what's commonly called the major questions doctrine, or at least that's what it's been called now. And the basic premise there is that when it comes to big policy matters, this body, the Congress, makes the decision on where the legislation is supposed to go, and not a regulatory agency unless Congress has spoken clearly and delegated certain authorities to that agency. Now, there's some disagreement among the justices about what it means, and Justice Amy Coney Barrett articulated a position in Biden v. Nebraska, the student loan case that just came down the end of last month, saying that really this is just more common sense analysis of reading a statute. So if the statute's all talking about one thing and then the agency goes off in some other direction, we're not going to read it that way unless the language is really clear that Congress is making that happen. So
speak to that example of those two court cases and apply it to the specific matter today about the Securities and Exchange Commission's ability to require climate-related disclosures.
Well, as I said in the Wall Street Journal last summer, if the EPA, the Environmental Protection Agency, is stepping out of bounds in doing various sorts of climate regulations, which was what the Supreme Court determined a year ago, clearly the Securities and Exchange Commission, which is about protecting investors so that they know what's going on in the companies they invest in, is going to be limited in what it can.
Now, has the SEC's position on climate disclosures changed? So, give an example of 2016 to today. Is there a difference?
Well, I mean, in 2010, the SEC came down with rules on climate change disclosure, but they were narrowly focused to material information, which really ought to be included anyway in disclosures. And then in 2016, the SEC came out with a policy statement saying, this is really, the broad issue here is off limits. And then just last year, they sort of basically reversed course on that, and they came out with disclosure requirements extending to vendors, non-material information, board decision-making, and all sorts of things. I filed a comment letter extensively to the Commission.
So let's speak to that. Mr. Cunningham, can you speak to the question of materiality and its import with securities disclosures historically?
Yeah, it's a fundamental principle of the securities law jurisprudence that the purpose of disclosure is to provide information that a reasonable investor would consider important in making an investment or voting decision. And that articulation is of long-standing Supreme Court vintage. Now, there are some small details within the securities framework that might be required that wouldn't satisfy that definition, but much of the bulk of the pending climate disclosure rule dispenses with that constraint, and I think that's the concern.
So how does materiality benefit, this question of materiality, benefit an average investor?
Because investors will only be given information that it's useful to them in making their investment decisions. The real risk of the floodgates are overwhelming investors with abundant information they can't make sense of and they can't use. So the materiality threshold is really a good filter that's useful for them.
Okay, so is there a reason to deviate from that principle in light of climate or environmental concerns?
No, and it's hard to think of why an investor would care about trivial information or an avalanche of information that would drown them in useless detail. And I think that's the big concern.
Okay. So thank you for your testimony. I want to thank the panel, and we'll now recognize the ranking member for 5 minutes.